Good afternoon, Judge.
Good afternoon.
Good afternoon.
All right. Is everyone here on Cantu versus Smith?
Yes, Your Honor.
All right, let's go on the record. Tony, are you there?
Yes, Judge.
Let's go on the record on DC 22-10595, Cantu versus Smith. Counsel, make your appearances.
Your Honor, Stacy Dunlop on behalf of the plaintiff, Laura Cantu.
Brian Gillette on behalf of the defendants, and with me is Lauren Green on the Zoom.
All right. Is Miss Green, if she's going to be arguing, she needs to turn on her camera.
I'll be doing the arguing, Your Honor.
Okay. All right, let's proceed.
Your Honor, I have an objection I'd like to assert before we go into the meat of the motion.
Okay.
Thank you, Judge. This is you've heard the motion for summary judgment by the defendants before. You made a ruling, you heard all of the argument. There have been no new substance to the second motion for summary judgment. So this is really just a motion to reconsider. So I'm asking the court to sustain my objection and not have us re-argue the same motion over again.
Yeah, I did read it. I kind of agree with Mr. Dunlop. It just kind of seemed like a second bite at the apple.
Well, Judge, I don't think it's really a second bite at the apple. I think there were a couple of questions that were left hanging at the last hearing. One about whether collateral estoppel could be invoked by parties who were not party to a prior action. And that wasn't really the focus of our prior presentation, but the motion is intended to clarify that yes, indeed, the law is very clear that collateral estoppel can be invoked by anybody, regardless of whether they were in the prior action, as long as it's being invoked against, well, here, the plaintiff who was in the prior action. And so that's one point. And the second was the court had a question about whether exploitation could, under the statute, could include things like the kickback allegations that were made or the dual skilling allegations that were made. And that was also not a focus of the prior motion. So this second motion is really intended to offer some clarity on those two narrow points and hopefully, put an end to those claims so that we don't have to go forward to a trial next month. And if the court disagrees, then certainly that's its prerogative and we'll have the trial. But we'd like to have the opportunity to present on those 2 points so the court has a full information about whether it believes that there is a scintilla of evidence that would support trying this to a fact finder.
Yeah, I think his response basically confirms that there's no new material for you to consider, and you didn't hold your rulings subject to a subsequent briefs or subsequent to any questions that you may have had being answered. You made rulings, and so none of the issues, as Mr. Gillette, I think, concedes, are new. It's just that he's saying we want to refocus on those again and be able to basically try to convince you to rule differently than what you did before. And you didn't give us any homework or any assignments to brief any questions that you may have had.
So this is what I'm going to do. I'm going to deny the summary judgment on the exploitation issue. I think that's already been addressed. I'm going to not going to reconsider my ruling on that. I do want to hear the argument on the collateral estoppel as to the other defendants on the, I think it's breach of contract claim.
Yes, Judge. And I know we have a brief time, so I'll jump right in. May I be allowed to share my screen?
Sure. Go ahead.
All right. So on collateral estoppel, the law is very clear that as long as the party against whom collateral estoppel is being invoked was a party to the prior proceeding, then anybody may use collateral estoppel against that party. And in this case, the Texas Workforce Commission considered the plaintiff's wage claim, determined that she was not entitled to any unpaid PTO under a contract, and it actually considered the employment contract that the plaintiff has attached to her summary judgment response. And so in this case, the court previously granted summary judgment based on collateral estoppel to the defendant that was in the TWC action, Rolling Meadows Hospice LLC, but it denied it as to the other defendants. And so this case law that we cited on the screen shows that the other defendants are equally entitled to assert collateral estoppel as to the issue of whether the plaintiff has a contract that provides for paid time off benefits. We have language from the Texas Supreme Court that it is only necessary that the party against whom the plea of collateral estoppel is being asserted be a party or in privity with a party in the prior litigation. And from the Dallas Court of Appeals that says it even more clearly that parties in a subsequent suit may invoke collateral estoppel even if they did not participate in the first suit, as long as the party against whom it's asserted was either a party or in privity with the party in the earlier litigation. The plaintiff has responded by citing a statute in the Labor Code, section 213007, which, to be fair, that section does say that collateral estoppel does not apply, but only to certain actions. It applies to findings, conclusions, judgments, or final orders made under this subtitle. And this subtitle is Title IV, Subtitle A, the Texas Unemployment Compensation Act. Here we have the Texas Workforce Commission's ruling. It is under Chapter 61, which is in Title II, Subtitle C, relating to wages. So not only is it not in that subtitle, it is not even in the same title. So that's the only argument the plaintiff has made against applying collateral estoppel here, and it is wrong as a matter of statutory interpretation. So there is simply no basis not to dismiss the breach of contract claim, which seeks paid time off benefits when the plaintiff has already litigated and lost on that issue, and any defendant is now entitled to invoke collateral estoppel to prevent her from relitigating that issue. We would also object at this point to the plaintiff's Exhibit A, which is the employment agreement that was litigated in the Texas Workforce Commission proceeding. It's the only evidence she has of an employment agreement. As an initial matter, it doesn't provide for paid time off benefits, but it's also a document that she has claimed throughout this litigation is void and invalid and unenforceable and a forgery that she didn't sign. So she should not be allowed to rely on it as evidence at this point, Your Honor.
Okay, response?
Thank you, Judge. If Mr. Gillette could please stop sharing so that I can see you. I don't see you. Okay, there. Now, thank you, Judge. So yes, the Texas Workforce Commission, under that particular section, it does say that that the Workforce Commission, the findings of the Workforce Commission have no collateral estoppel effect. And, Your Honor, there's some other language in commentaries that talk about that rule, and it says that the court, that it is basically the mere possibility that collateral estoppel will be applied as a potential, has the potential for bogging down the appeals process under the Texas Unemployment Compensation Act by protracted litigation where further litigation is contemplated in other forms involving the same facts and parties. And basically the legislature's intent is that the commission's administrative decisions, regardless of what type they are, but the commission's administrative decisions are not admissible in matters of collateral estoppel in litigation. So as the commentary reflects, it's not unique to any one particular type of action. Further, as it relates to the contract that was produced by the defendants during the litigation and part of the discovery, we believe on its face shows that there's some discrepancies and perhaps even forgeries. To be clear, our position is that there was a subsequent agreement, whether that one was a valid one or not. It doesn't appear that that's a valid one, but there's a subsequent agreement that appointed and promoted our client to being COO of the company. And so to the extent that the agreement was produced by the defendants, what it does do is it at least acknowledges whether it's a forgery or not, that they believed and confirm with us and agree with us that there was a contractual relationship for the employment between Laura Cantu and the defendants. And so, Your Honor, she was the COO of the company. She had when she made her demand for PTO, they didn't respond with a, what do you mean PTO? Instead, they started to try to haggle it or even make partial payments regarding the PTO.
Okay, so let's go back for a second. So, Mr. Gillette, can you share screen the section on collateral estoppel involving the Workforce Commission? Just share screen that particular slide. So it's collateral estoppel is inapplicable.
Right. That's our position, Your Honor. And that is not just unique to just that, not just unique to unemployment claims, but basically by findings of the commission's administrative decisions, period. And I don't think Mr. Gillette pointed to anything that shows that in any other administrative decision that it would be appropriate for collateral estoppel to be in effect or used.
Judge, may I respond briefly on this point? The language of the statute says that findings, conclusions, judgments, and final orders made under this subtitle. So a TWC finding in an unemployment compensation proceeding does not give rise to collateral estoppel. But Ms. Cantu did not bring an unemployment proceeding. She brought a wage proceeding seeking wages for her vacation and PTO wages under Chapter 61, which is not in the Unemployment Compensation Act. So this statute does not apply to anything unless the TWC proceeding in the prior action was an unemployment action. And so on its face, it doesn't apply to this action. All other TWC actions do give rise to collateral estoppel.
And that last sentence, Your Honor, is the part that I'm saying I don't think Mr. Gillette has support.
Well, let's break this down. It says a finding of fact, conclusion of law, judgment, or final order made under this subtitle. So that's the ruling that was made was under this subtitle, correct?
No, Judge. The ruling was made pursuant to Chapter 61 of the Texas Labor Code. This was a preliminary wage determination order that ended up becoming final because she didn't appeal it. Wages are under Chapter 61. Chapter 61 is in the wages subtitle, not the unemployment subtitle. So this decision was not made under this subtitle, which is subtitle A, which contains Chapter 213. So this collateral estoppel is inapplicable statute only applies where the TWC proceeding was an unemployment action. And Ms. Cantu's TWC proceeding was not an unemployment action. So this statute was never triggered, and it doesn't apply here.
And Your Honor, it's that last sentence, it doesn't apply here, is what I'm saying, that I don't think Mr. Gillette supports with statutes or case law to show that the legislative intent is that these type of findings by the commission, these administrative decisions, are not admissible in matters of collateral estoppel in litigation. And I talk about that in my response. But also, Judge,
are there any cases, maybe if you go back, any cases under Chapter 61 of the Labor Code that have applied collateral estoppel?
Well, in general, TWC orders are given collateral estoppel effect.
Well, okay, then I guess, are there any cases that apply any sections other than 213?
The only cases that plaintiff has cited in her brief were attempting to use collateral estoppel from an unemployment action under Chapter 213. And the courts held that the statute prevented them from doing that. The statute here does allow limited collateral estoppel when the subsequent action is also an unemployment action. You know, prior unemployment decision can give rise to collateral estoppel in an unemployment decision, but it doesn't give rise to collateral estoppel in other actions. So if Ms. Cantu had brought an unemployment action and then later filed litigation on a wage action, couldn't use issues determined in the unemployment action as collateral estoppel in the subsequent wage action.
I guess what my question is, and I wasn't very clear on this, are there any cases that have applied any labor code provisions other than obviously 213 that have found that collateral estoppel applied to the workforce commissions?
We haven't identified cases specific to different provisions of the labor code. Plaintiff's response brief cites the one case from the Fifth Circuit that was an unemployment action followed by a different type of action, and it refused to apply collateral estoppel because it was a prior unemployment action. But plaintiff has not cited any cases
Section
that would
213.
extend 213 beyond the limited scope of prior unemployment actions.
Can someone share screen that case so I can see it? Does anyone have a copy of the case?
I'm pulling it up right now, Your Honor.
Yep.
Do you see the Atkinson versus Denton Publishing Company case
Yes.
on the screen? Okay.
And was this section 213 in existence at that time?
This case, I believe, cited section 213.
Let me see that.
It was the predecessor.
This is pretty strong language. All right. Okay, I'm denying the summary judgment. Do we have you presented an order on this?
I did not. I can prepare one real quick and knock that out real quick. I didn't know how you would rule on the objections or so I can just not prepare one and have it to you before the end of the afternoon if you so desire, Judge.
Yeah, make sure it says that it's heard. This was heard on March 11, 2024. Share a copy of it with Mr. Gillette and get it to me by first thing in the morning.
Thank you, Judge.
All right. You guys have a great rest of your day.
Thank you.
Our next hearing is the 145 hearing on Daryl Cook versus Alakin Stone and Stucco.
Yes, Your Honor. Maria Martinez here on behalf of the plaintiff.
Are both sides here? Mr. Stewart, what are you here for?
I was told to log in at 2 o'clock.
For what?
To be questioned.
On what case?
Connor Duff and Spiro.
Okay.
Trzecki.
Maria Martinez, what are you here for?
I'm here for the case that you just called, Daryl
Okay,
W.
all
Cook.
right. Okay. Let's go on the record on cause number DC 195770, Daryl Cook, PC versus Alekin Stone and Stucco. Council, make your appearances.
Thank you, Your Honor. My name is Maria Martinez, and I'm here on behalf of the plaintiff.
Okay, you may proceed.
Thank you. Your Honor, this is a post-judgment motion for contempt. Judgment creditor obtained a default judgment on May 31st, 2019. The judgment is currently valued at $7,876.06. Post-judgment request for production of documents and tangible things were served on July 15, 2021 on defendant. Judgment debtor failed to respond by the deadline as provided by the Texas Rules of Civil Procedure. Judgment creditor filed a motion to compel and received an order compelling defendant to give discovery responses and for sanctions dated September 12, 2022. This ordered defendant to respond to the request by October 12, 2022. A copy of the order was sent to defendant on September 22nd, 2022. Defendant failed to provide any responses. Our office attempted to confer with the judgment debtor on October 17, 2022. Via conference letter, defendant failed to respond to any of our conference attempts. Plaintiff's motion for contempt for failure to obey a court order and show cause was filed on October 11, 2023. And this hearing was set. A notice of hearing was sent to defendant via certified mail and first class mail on February 6, 2024. We are asking that the court grant us attorney's fees in the amount of $2,500 for receiving and analyzing the files, correspondence with the client, preparation of plaintiff's post-judgment request for production interrogatories, arranging for service on defendant, preparation, filing a motion for contempt, research of the law, research regarding this defendant, and general correspondence concerning this case, Your Honor.
Okay, so you have a couple of different orders you guys submitted. And I wanted to kind of figure out what you were hoping me that I would sign today. Is this the order you wanted me to sign?
Do you mind showing me that second page? I'm sorry. Thank you. Yes, Your Honor.
Okay. You're requesting $2,000.
2,500.
And we want this received within. Okay, we'll have it due March 25th, 2024, 5 p.m. All right, is that the only order you wanted me to sign today?
Yes, Your Honor.
Okay, you signed it. You have a great rest of your day.
Thank you, Your Honor. May I be dismissed?
You may.
Thank you.
Okay.